Good afternoon. Drew Bosson with Atlas Injury Prevention Solutions, coming to you today from Pittsburgh, Pennsylvania. I'm here today with Albert Lee of the law firm of Tucker Arensberg. Albert received his law degree from the University of Pittsburgh School of Law. In addition, he has a Bachelor of Arts degree in mathematics and a Bachelor of Science and Engineering degree in computer science and engineering from the University of Pennsylvania. He is a partner in the law firm of Tucker Arensberg here in Pittsburgh. Our organization has been working with Albert and his firm for the past many years to enhance our understanding and execution of our post-offer pre-employment screening offering to the marketplace. Over the next several weeks, we are going to be taking a deeper dive into the nuances of the law as it relates to post-offer pre-employment screens. Albert, legal issues have the potential to rise when differing perspectives and expectations collide. I've seen this in the scope of the delivery of post-offer pre-employment screens. If you will, describe those perspectives from the vantage point of the employer, the employee, and I guess most importantly, how the law interprets those.
The very common situation where an employer wants to gather information about a prospective candidate's medical history, background, physical capabilities, what they can do, what they can't do. That's a very common situation that has a lot of different perspectives depending upon which party you are in that transaction. If you're the employer, your perspective seems very clear. I run, manage, own a business. I have to make sure that the people I hire can do the job and can do it safely so that they don't get hurt, customers don't get hurt, coworkers don't get hurt. And in order for me to do that, I ought to be able to get a lot of information about someone's medical history, medical past, physical capabilities, and all that. And I ought to be able to act on that to be triple safe, super sure that no one is in the position where they or someone else gets hurt. Sounds very clear. Sounds clear until you look at it from the perspective of the applicant. The applicant comes at this and says, I want a job. I should be entitled to a job as long as I can do it. And my medical past, my medical history, particularly if it involves things like mental health history, that's kind of my business. It really shouldn't be anyone's business, the organic parts of my medical history, unless it has strictly to do with whether I can do this job. So those perspectives are completely different. So if you're an employer who's looking at doing pre-screens to gather the kind of information you want to have to rule in or rule out candidates, what you really have to realize is that there's a third perspective. And the third perspective is the legal perspective. The law says, you employer and you candidate, I get what you both are saying, but neither of you are 100% right. There's a middle ground here, and what the law is going to require is for us to balance those interests. Balance what the employer says it needs, balance what the candidate says he or she needs, and come in with something in the middle so that we strike a global result that ends up with people, the right people getting to work, getting these jobs and working without too much being shared. And the law does that through a bunch of different statutes that can nibble and peck at this situation. The two primary laws that come into play are federal laws called the Americans with Disabilities Act, or the ADA, or GINA, the Genetic Information Non-Discrimination Act.